Welcome back. I advocate Kritika on behalf of India Juris Mediation Services welcome you all and our esteemed panelists on our 7th webinar and interactive session on online institutional mediation episode number 7. So IGMS has been set up by India Juris for providing institutional mediation services. IGMS strives to become a leading mediation service provider in terms of Mediation Act 2023. India Juris is a full service international law firm with offices at New Delhi, Gurugram, Bangalore, Mumbai, and Gift City, having global clientele. To propagate information and share knowledge about the mediation, IGMS has started a series of webinars to touch and deliberate upon various aspects of mediation. Today is the 7th webinar of such series. In today's webinar, we will have a presentation on online institutional mediation and role of mediator in IPR by the panelist, followed by a panel discussion question and answers. To deliberate and enlighten us on today's topic, we are joined with three experts on ADR, IBC, and IPR. First, we have Mr. Sarvesh Kashyap, advocate and insolvency professional and IICA certified mediator, having experience of more than 2 decades in the field of corporate laws and matters pertaining to IBC. Second, we
Thank you,
have.
Kritika.
You're welcome, sir. Second, we have Mrs. Girija Krishnan Verma, ADR IP expert and ISCA certified mediator, having decades of experience in the field.
Hello.
Last but not the least, we have Mr. Samir Rastogi, managing partner at India Juris with more than 25 years of experience.
Thank you, Kritika. It's a pleasure to be on this webinar.
So the participant may drop their queries in the chat box. Now I request Mr. Rastogi for his presentation.
So thank you, Kritika. But before going forward, I would like to thank Ms. Girja to be for accepting the invitation to be one of our co-panelists to give her views, her on the mediation from IPR disputes and various other aspects. And I also welcome Sarveshji on this webinar. So he is very experienced on this aspect. So,
We are grateful to you, Samir and Kritika, for giving us this opportunity to speak to the participants and give us a platform to speak from on the subject. Thank you.
So thank you. So here I think we have participants who are advocates and who are looking mediation as a prospective profession. So this is a information dissemination effort you can say, and this aspect. So today we are going to deal with. We have selected the topic of institutional mediation. So we'll speak about it and we'll discuss various things on IPR, and then we take with Ms. Girja. She has extreme experience on IPR, so we'll take her experience into mediation as well to deliberate upon IPR disputes. So let us start with our presentation, and then we have Ms. Girja on IPRs. So I'll share my screen. So I think my screen is visible to everybody.
Yes, it is.
So friends, this is today's 7th webinar in this series, and the topic which we have spotlighted on this webinar is online institutional mediation. So before moving forward, as usual, we'll recap what we have done in our previous webinars just for the information of the participants. So in our previous webinars, we have dealt upon mediation agreement. We spoke about pre-litigation mediation, matters not fit for mediation, appointment of mediator and commencement of mediation, conduct and role of mediator. We also spoke on registration, enforcement, and challenge to mediation settlement agreement. In our various webinars, we also dealt with the provisions relating to non-settlement report. So whenever the mediation is ends up without any settlement, then the mediator is required to file this NSR. So we spoke about this. We spoke about online mediation, how the mediation can be terminated. Mediation council, very important thing. We discussed at large on this. Then MSP and its function. So MSP is very interesting thing over here. We dealt with this, and we'll speak that on that in this webinar as well. And then we spoke about community mediation. So these are some of the aspects which we covered on detail. We discussed a lot, and I think all these points which we discussed are available on the webinar recording webinar. So whoever is interested in like to revisit this discussion on these points, they may look at the webinars recording. So before going forward to start this institutional mediation, so I would like to bring to the attention of the audience, the participants. Many of you are advocates, they must be having the BEAR Act, and if you go to the introduction, the object of this particular act, Mediation Act 2023, which has come in December 2023. So what it says, it seeks to promote, facilitate mediation, especially institutional mediation. So the very object of the Mediation Act 2023 is to promote especially institutional mediation. Means the wholehearted intent of the government, of the legislature, is to promote institutional mediation so that it come up like a profession, and it can service the community, the businesses in our country. So especially institutional mediation for the resolution of disputes, commercial or otherwise, to enforce mediated settlement agreements, to provide for the body for registration of mediators. So these are the various things which are the object of this act. And all these things are related to institutional mediation. How they are related, we'll see in this particular presentation. To encourage community mediation and to make online mediation an effective manner. You know, the technology is coming like anything. The AI, the technology has gone deep down in our lives, in our profession, in our all kind of work. So even the legal profession or the such kind of dispute resolution services cannot be left alone and will not be left alone. So there also the impact of online, the technology is there. So before we proceed on institutional mediation, to take the audiences on the path of institutional mediation, so I have just put in the relevant definitions from the act, which will track us to the institutional mediation. So before we go to institutional mediation, we see what is mediation. So I think most of the participants who are here would already know what is mediation. It's a voluntary thing done by the parties. But how the act says is, what are the words provided in the act for mediation? So let us see that before we go on to the institutional mediation. So the section 3H of the Mediation Act 2023, it provides, so it's an inclusive definition that it includes. It's not only this, there can be any other thing as well. But it includes, whether referred by expression mediation or anyway, whatever you may call, pre-litigation mediation, online mediation, community mediation. So three things there expressly say that it includes pre-litigation mediation, online mediation, and community mediation. Conciliation or expression of similar import, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as mediator, who has no authority to impose settlement upon the parties to the dispute. So now this is mediation. And very simple, when we talk about institutional mediation, in institutional mediation part is this. It means institutional mediation would apply to pre-litigation also mediation. It would be a uh, online mediation also. It would be a community mediation also. And even if the institutional mediation is done, the mediator will not have authority to impose the settlement upon the parties. So this is what the acts provide. So when we have seen what is mediation provided in the act, we go on to the next, institutional mediation. One, we just saw mediation. Now we are looking at institutional mediation. So section 3F is providing for institutional mediation. Means mediation conducted under the aegis of mediation service provider. So now here the term used is mediation service provider. And now the participant may note that the word is not conducted by, it says conducted under the aegis of mediation service provider. So it is indicating that mediation service provider would be some agency or it would be some body, and under that there will be mediators who would be providing this. So this is indication from the definition itself. So it says under the aegis of mediation service provider, which is MSP. Third, now what is mediation? Now it leads to another question: what is mediation service provider? So section 3M says mediation service provider means a mediation service provider referred to in section 40 subsection 1 of Mediation Act. So now this mediation service provider is the new creation of the law in this particular act. Those who are insolvency professionals, you must be knowing that we have IPE, insolvency professional entity, and we have insolvency professionals individual as well. So similarly here we have mediators and we have mediation service provider entity. So this is on the same pattern as we see in IBC. So mediation service provider, what is mediation service provider? Let's see that. So mediation service providers under section 41, it includes body or organization that provides for conduct of mediation. So in the earlier definition MSP, it was under the aegis. Now for mediation service under the aegis of MSP, and now for MSP it says it conducts. So now MSP would conduct the mediation. The bodies or organization that provides for conduct of mediation recognized by the council. So the council here it is to be made, which is mediation council, and like IPE are registered with IBBI. Similarly, the MSP would be registered with mediation council. On the same pattern as we talk about IGMS, so we are waiting when the regulations and things are available. So we'll register it as an MSP with the council. So another B and C, this is authority under legal service authority and court annexed mediation and any other body node. So this B, C, D are already deemed as MSP recognized by the council, by law itself. So point A is for private like us to go and get registered with the mediation council and become an MSP, registered MSP. So friend, now we see what is mediation, what is institutional mediation. Means institutional mediation means conduct which is under the aegis of MSP. So institutional mediation is not referring to a mediation conducted by an individual. So it is under the aegis of MSP. And what is MSP? We just saw it is a registered body with the council. And we are waiting for the regulations to come out. We would know what should be the constitution of MSP, how many registered, what kind of registered mediator should be there in that. So all those things are we are yet to see. So what are the functions of MSP? What this MSP would do? Who would be undertaking? Who would be conducting the institutional mediation? So what they would do? Accredited mediators and maintain panel of mediators. Accredit mediators and maintain panel of mediators. So now you can see, friends, that the MSP would be accrediting mediators and how it would be the rules we are yet to see, and maintain a panel. So IGMS will also maintain a panel of mediators globally. So basis on the dispute, their expertise, we would appoint or we would select certain mediators. So provide the services of mediators for the conduct of mediation. So these are the functions of the MSP for institutional mediation. Offer all facility. So MSP may do any kind of, they can help companies or individuals or community. So, but whatever mediation they are conducting, that is referred to as institutional mediation. So offer all facilities, secretarial assistance and infrastructure to ensure efficient conduct of mediation. Promote professional and ethical conduct amongst mediators. Facilitate registration of MSA as section 20 under section 20 as per section 20. So MSA is mediation settlement agreement. So once mediation settlement agreement is entered between the parties, so you have an option to get it registered. If you want to register, then it will facilitate in registration of that agreement as well. So perform any function as may be specified. So you can say whole preparation has been done to register MSA, MSP, and to take on the profession of mediation like a very organized profession. So friends, we just saw what is mediation, what is institutional mediation. It is covered by it is done by the MSPs. What is MSP? So now in the first slide, we saw the mediation, the institutional mediation would include pre-litigation mediation also and online mediation also. The only thing is it would be under the aegis of MSP. So we are just highlighting what is pre-litigation mediation from the act point of view and online mediation. And then we go further on that particular aspect. So before instituting a suit, parties may voluntarily or by way of mutual consent refer civil or commercial dispute for settlement. So even before you are going to litigation, so prior to that, you can voluntarily go for a mediation. So here, whether it is online or pre-litigation slides over here. So we are trying to just give a taste what MSP would be doing. This section emphasizes the importance of attempting mediation before resorting to litigation. So this work before, if somebody wants to resort to mediation prior to entering into litigation, so they can approach an MSP, whoever is registered with, so they can go with MSP and under the Mediation Act, the mediation can be done, MSA can be made, it can be registered. They can get all the facilities, all the support, what we just said that MSP will provide. Similarly, in institutional mediation, online mediation, they can do online mediation as well. Because as I said, the advent of technology has made things easier, cost effective, less time consuming. So MSP would definitely, make all arrangements where they can do mediation online to reduce time cost and inconvenience to the parties. So online mediation, including pre-litigation mediation can be online as well. Can be conducted at any stage with written consent from all the parties by using various electronic forms like encrypted emails, secure chat rooms, or videos. So these are the technological things how the MSP would, all these things, I presume that would make all these arrangements when somebody is approaching them for institutional mediation. They would provide all these facilities to the parties who are applying to resolve their dispute. So obviously in online mediation, integrity and confidentiality is one of the major things. So there should not be leak of any information. So they would have different technical and other measures to ensure the confidentiality. Even the mediator who is undertaking the mediation online, he would also ensure the integrity and confidentiality. And that is the main thing in the digital world. So till now we saw the background of institutional mediation, what we have done, what we did in our last webinars, how the Mediation Act object proposes for institutional mediation and various definitions linking to each other to covering the whole circle of the institutional mediation. So now institutional mediation transforming disagreements into understanding through institution. So now we are going to institutional. If you go to the WARE Act, you will not find any specific clause or section which is detailed on institutional mediation. But from if you link it all the clauses as we have just explained, so you would get the whole landscape of institutional mediation. So this what we I'm written here. It is not from the act, but it is from the explanation what institutional mediation would do. So it would definitely the institutional mediation means it would be the MSP who would be doing all these things, facilitates the resolution of conflict within organization, institution, or workplaces, enable parties to address. Well, one thing you see when we talk about institutional mediation, we are talking about that there is an MSP, it's an organization, and they have their whole infrastructure, team, support staff to deal with institutional mediation, to deal with big mediation matter. For example, there are two company mediation can be between two large corporates, various businesses. So definitely to deal such kind of disputes or to resolve these disputes, lot of huge document reviews required, lot of meetings are there. So you need a team, you need infrastructure, you need various things. So obviously, when we're talking about institutional mediation, so it has to facilitate the resolution. So what I see in coming time, we will, if the things are going as the government is trying to push, we may have huge mediation centers with big facilities. Facilitate the resolution of conflicts with organization, institution, or workplace. It enable parties to address disputes, improve communication, and strengthen relationship, promoting harmonious and so these are more of a subjective things what institutional mediation would involve or would do. So they would have trained neutrals, mean obviously trained neutral mediators would assist parties in identifying issues, exploring solutions, and finding mutually beneficial agreements. So this is it is a normal that in every mediation it would help, but it would in institutional mediations it will be more of a higher level, I would say, on a organized manner, more for a large companies and businesses. So objective to enforce MSA ensure the agreements reached through mediation are legally binding and enforceable. As we see institution, the MSP would be helping and responsible for registering the MSAs, getting it that these are properly signed, they are authenticated by the mediators because the Mediation Act provides that when the MSAs are done, it will be signed by the parties and authenticated by the mediator. So all the institutional mediation, the MSP would ensure that everything is in place. They would maintain a panel of mediator. For example, today if you have to hire some mediator on a particular, suppose you are let's say you are a telecom company and you have a dispute with other telecom company or anybody or service provider, then you would like to have some mediator who has the knowledge of telecom sector, who knows about it, how the things go. So as we all know in mediation, we don't want a lawyer to do it. It has to nothing to do with that the mediator must be a lawyer. Mediator must be skillful, fully trained to resolve in dispute. So as I said, suppose that you are a company and who has as a telecom company want to resolve certain dispute with their vendors or with their service provider. So definitely you would like to have a mediator who has telecom background, who knows how the things work in telecom sector. So there, that is the place where MSP comes into picture. So MSP would have the empaneled mediators. They would say, okay, if you want a telecom mediator having telecom background, we have these people empaneled with us who are veterans in telecom sector, and they would be and they are certified mediators as well. So that these people may be engineers, they may be contract negotiators, they may be anything from telecom sector. So they may be a wonderful choice for appointing as a mediator. So all these things, the discovery of people can be done by mediator. They will make a mediators panel with them, which can be easily accessible to the people who want mediation to be done. Encourage community mediation, promote mediation at community level, and resolve. So all these things you will see the object of whether you call it object of institutional mediation or you say what the institutional mediation can achieve. It everything is indicating the same direction. Make online mediation acceptable and cost effective. So when we are talking about institutional mediation, obviously the one thinking may be that the mediation may be done online. If you see the object of the act also, it provides online mediation. So they want to promote institutional online mediation. So there's an MSP who has made all arrangements. People go and do it online, reduce their cost and time and effort. And the burden of Indian legal system or the courts may also get reduced if the things are start happening very fast. So it facilitates resolution of dispute with standard. So conflict of interest. So this conflict of interest I have selected only just to tell what is there in case of conflict of interest and disclosure. So in case of mediation, the mediator has to disclose his if there is any conflict of interest. The mediator may have given some opinion, they would have working for them or they are related to them, whatever. So if upon disclosure, if the conflict of interest is there and either of the party wants to replace the mediator, then in case if it is an institutional mediation, then the party will write to their MSP. For example, some mediation is taking place and the MSP is IJMS, and either of the party finds that the mediator has disclosed something which they are uncomfortable and they want to replace the mediator. Then the party who want to replace, they will write to IJMS, and IJMS will terminate the mandate of that mediator and appoint a new one. So that's how it is. So in case of an institution mediation, if you want to remove a mediator, then you have to write it to the MSP. And if it is non-institutional, it is appointed by the two parties themselves, so they can terminate anytime. So it's that way. So from that point of view, this slide I kept that how if you have selected institutional mediation, how you can terminate or change the mediator. Mediator role, I think it is not exactly, it is a general thing. Mediator, whether it's a institutional mediation or non-institutional mediation, the role of the mediator remains the same. But in institutional mediation, the way of doing the same things may be a little different. The doing same things in physical mode and online mode may be different. So just to give a highlight what the mediator do or what is the role of the mediator, whether in institutional mediation or non-institutional mediation, he will identify the issues, what are the issues between the parties. He will try to clear misunderstanding. He will suggest solutions. He will not give his own solution. Basically, what he will do, he will try to find out what the parties are proposing, and from there only he will, encourage them to arrive best of the solution what they have proposed. So, as we said, the law clearly says he will not impose any solution or settlement among the parties. So conduct a separate meeting. So in physical, you can have a separate meetings in different rooms. But when you are online, so now the the digital platform have been made where you can do caucus in some different chat rooms or different video rooms. So that is there. So parties exchange memoranda, outline this. So all this is the mediator role. I mean, if we can write this role of mediator in different manner also, because if somebody who is doing a IICA certified mediators course, or they are getting some certification or doing certain course, they would find that it is written in it is written in a general fashion, but you would find a more detailed role of the arbitrator in those courses. Somebody who's interested, they can try out the course from IICA or the Supreme Court as per the Supreme Court guideline. So non-settlement report, as I said, give normally. So NSR we have selected because of wherever there is an institutional mediation related thing is coming, so we have put this slide. So what is saying, if there is no agreement between 120 plus 60, 180 days, the mediator is no settlement is possible. Then the NSR, then it is non-settlement report has to be filed. But what happens when in case of institutional mediation? So in case of institutional mediation, the mediator will submit his NSR to the MSP in that. That's how it is. So in case of institutional mediation, the NSR will go to the MSP. In all other cases, prepare NSR and provide a signed copy to all the parties. The report shall be confidential and not disclose the cause of non-settlement during the meeting. So confidentiality will always be maintained. The only point to mention is here in case of this NSR will be submitted by the mediator to the MSP instead of parties. So, but this was about a gist about institutional mediation and various things which are linking to institutional mediation in the act. And as we said that we are just trying to see how the mediation can be implemented or drawn towards intellectual property related disputes. Because if you see a lot of companies, a lot of businesses, intellectual property is a very integral part of all businesses. You must be looking at today, huge businesses are going on, the stock market is up, the companies are doing big business. So wherever there is an increase in business, there is increase in valuation. And when you talk about increase in valuation, it inherently increased valuation means the IPR is the IPR of the company has a role in the valuation of the company. So obviously, wherever there is a valuable thing, there will be disputes. So now the disputes, can those disputes be in mediated and how it should be done? So we would hear Ms. Girija on that. But just to set the tone for her to come and let us know her views. So for the benefit of the participants, so what are IP disputes, intellectual property disputes? So it arises from the infringement or unauthorized use. So how the IP disputes would arise from infringement or the unauthorized use? So there is no intention whether the party had intentionally or intentionally infringed kar diya to kar diya. So it's like that. So when we're talking about IPR, most of you would be knowing it's copyright, trademark, patent, trade secret, knowledge, know-how. So I would not go more on the IPRs. We are waiting to listen to Ms. Girija. So importance of IP protection. We know whoever invents, whoever sweats for inventing something or creating something or promoting something. So it is a big loss to them if they are infringed or if somebody breaches or violates their rights. Obviously, it is so important to protect. For example, let us say Facebook, somebody else uses starting name Facebook. Facebook will not allow. So that is you can imagine the importance of IP protection. So they will spend any money to protect their IPR, their name, their trade, their logo. So types of IPR suitable for mediation. So we have just written, I don't know how much it would be. We'll listen from Ms. Girija. Patent disputes, the disputes can be related to the patents, trademarks, copyrights, trade secret, domain name disputes. But everywhere, the intent, all these disputes will be in the light of Mediation Act. Whether when they are mediation, they are referred to mediation means the party should voluntarily agree to submit to it. Otherwise, nothing will happen. So I think, friends, with this, we are on we had a glimpse of institutional mediation, and I have tried to set the tone for IPR disputes in institutional disputes, which can be bring into mediation. So over to you, Kritika. Before we take questions, we'll take questions in the last, and over to you. Thank you.
So thank you, Mr. Rastogi, for this wonderful presentation. So now I would like to request Mrs. Girija to share her expertise on critical aspects of dispute resolution on IPR.
Thank you very much, Sameer. That was a very good, detailed discussion on mediation and its nuances. And I also thank Kritika for this introduction here. I'll quickly give you a little background as to what IP disputes are generally, and then we'll go on to more specifics of mediation and IP disputes. So basically, what is intellectual property? I think a lot of you would know about it, but I will just give you a quick rundown. They're basically legal rights that are creations of the mind. They are such as inventions, literary works, books, artistic creations, inventions. They're also known as industrial property, which includes patents basically, which protect inventions, their technical products, processes, trademarks, industrial designs, and models. And then there is copyright, and as there's also another one which I think was not in Samir's presentation is database rights, which protect collection of data and information and material on the internet. And there are plant breeders' rights, which protect new plant varieties, and then the trademark law, the general litigation that we see largely in the courts. Now, mostly IPR rights are territorial rights. They'll be, or they belong to a, they'll be within one country. The Trademark and Patents Office will grant a registration for that country, and then the companies will take registration in different countries. So they are generally territorial rights, and they are meant to promote healthy competition and encourage industrial development. So they have unique set of legal issues. IPRs have unique set of legal issues. Mostly they could be issues relating to the ownership of the rights. Who is the owner? Whether in copyrights, we see this largely in a lot of cases, like say there is a song which is being sung, or there is a movie, or there is a there is a software being developed. There are various parties who are putting in different creations into it. Now, who is the owner of what becomes sometimes an issue. Then there are issues on buying and selling and assignment of rights. Then the licensing of intellectual property. Uh, Generally, we see a lot of litigation which is around infringement and counterfeiting of IP rights. Some of the common examples of such commercial transaction and relationships in relation to patents are patent and know-how, licenses, franchising, computer contracts, multimedia contracts, distribution contracts, joint venture and R&D contracts, technology-sensitive employment contracts, mergers and acquisitions, and where basically intellectual property is looked as an asset, and it assumes importance, and also publishing, music, and film contracts. So there are unique set of conflicts that arise in intellectual property. So I think they also require an additional skill or technical knowledge other than what you know as a skilled mediator to help you resolve IP disputes. Because there is a lot of domain expertise required. Say if there's a patent or an invention in the field of a mechanical device, then you should be aware of various mechanical devices, how they are being used, what is the invention, what is the prior art. So those issues arise. So some amount of technical and domain knowledge is essential. As it is, understanding IPR itself sometimes becomes challenging. So we generally encourage in IPR disputes that you look at a skilled mediator, and a skilled mediator with technical knowledge. I so there are two kind of techniques which are other than what that IP mediator would use in helping parties resolve the disputes. One is the general facilitative technique, which is used where the mediator is only acting as a facilitator and is getting the parties to come together and communicate with each other and find a solution, where the outcome and solution is largely found by the parties. The mediator's role is only as a facilitator. The other is where the mediator is using an evaluative technique. Now, because the mediator has domain knowledge, the mediator will evaluate the disputes, hear both the sides, hear the parties, evaluate the dispute, and then give kind of an opinion, or yes, some value is added to that, so that then the parties can see how they can find solutions. And then the mediator helps them find different options to help them find a resolution. We see a large amount of mediations happening as cross-border disputes because we'll see that intellectual property is held by large companies overseas in foreign countries, especially the US, Japan. They have a lot of patent um, patents in their names. The ownership lies in their companies in Japan, US, Europe, all over the world, and they are transferring know-how or technology to India, or they've made a product out of with that invention, and that's being sold in India. So we see a lot of cross-border disputes. It's essential that the mediator understands the licensing policies that these companies use in cross-border disputes, as well as the agreements that are entered in for marketing products which are, inventions or patents across borders. So again, some amount of technical and domain knowledge is essential in intellectual property disputes. One of the questions that keeps arising is whether IP disputes, it's mandatory to do pre-litigation um, pre-litigation mediation for IP disputes. Well, like any other dispute which is commercial in nature, like the Commercial Courts Act makes it mandatory to have pre-litigation mediation, but there is an exception, which is that in case the parties require any urgent ex parte orders, then they can approach the court directly without doing pre-litigation mediation. Most of the IP disputes center around ex parte ad interim relief. And then we see that then the matter comes for mediation after the court has either passed an order or not passed an order of injunction. So that's broadly what I would say about IPR disputes. Is there any specific questions? I can answer them as we move along. Thank you very much.
So, I would like to thank our panelists for this interactive and information presentation. Through this presentation, we explored the power of mediation in resolving disputes efficiently. So, institutional mediation, online mediation, how MSP functions, and the crucial role of mediator in IPR matters have shed new light on alternative dispute resolution. With mediation, how we can reduce litigation cost and enhance creditor debtor relationship and streamline the process. So now we would like to move to our panel discussion. So, moving to our panel discussion, I would like to invite Mr. Sarvesh Kashyap on this question. So, what is institutional mediation?
Yeah, Kritika, first of all, thank you, Girja ma'am, who has enlightened us on the IPR's matters. And about institutional mediations, basically, this is the concept outlined in the Mediation Act and which is already covered by Samir in his presentation. That institutional mediations generally this is conducted under the auspices of MSP. So this is already covered in the presentation of the Samir. And who is the MSP? MSP is in simple terms, mediation service providers is a body or an organization recognized by the mediation council that offers mediation services. They may be a public or private entity and must meet certain eligibility criteria and follow the standards set by the Act to qualify as official provider. If you see that Mediation Act is to formalize, promote mediation as an effective dispute resolution mechanism in India and encourage the use of institutional mediation. So that mediation is conducted in a systematic and regulated manner. So institutional mediation can offer be more accessible, cost effective, more specialized, provide a standardization framework, maintains panel of certified mediators, and adopt flexible approach tailored to client needs. So I think with the help of institutional mediation, the objective of the mediation act we achieve.
So
Yeah.
it is about the institutional mediation. So how does the involvement of institutional mediation impact the efficiency and outcome of IPR disputes? Ma'am, would you we would like to hear from you regarding the same.
So I think one of the key things that is required in intellectual property disputes is the domain expertise. So I think an institution can help bring that. Institution can bring in training, which is key for both training as a mediator, which is a skill. We all call it mediation skills, as well as training for IPR disputes. Because the IPR disputes has its own way of evolving and its own destiny, which sometimes differs from other kind of litigation. So I think that specialization can come in through an MSP or an institution that's helping a mediation institution. Further than that, I think the institution or the MSP can help in ensuring confidentiality because a lot of IPR disputes, there's an exchange of very, very key information about the invention, about its working, its marketing processes, its clients. So it's got very confidential information. So I think MSP can strongly enforce those rules. And of course, it's also conflict of interest, which you'd mentioned also is something which is very important. And then I think stamping and authentication by the MSP is very, very important because I have done some privately run mediations also. So the challenge always becomes now, how do you authenticate this document, which is the settlement agreement? Even though as a certified mediator, I can stamp it and sign it. But still, I think the parties feel more comfortable if there's an institution that puts a stamp on it and that gives them more, comfort in handling that document. And then in IPR disputes, very often you need to make comparisons of documents, comparisons of trademarks. An institution can help you get that documentation together and really review it properly with the parties sitting across with each other, which is something which you can't do in a court of law. And you can't also do, you know, you can do it as an individual mediator for sure, but an institution helps you get the parties to ensure they bring the documentation in and the relevant people from the organization in to help the mediation. And I think the institution also helps to ensure that the mediators follow a code of ethics. So I think broadly that's what it is. They can bring in technology and AI and all that, which is much easier for an institution to bring in as compared to, you know, individual mediators.
So, Ms. Girija, before she goes on with other questions, so I have an add-on question to this. You just
Yes.
said that the MSP or the organization, institutional, whichever institution is doing that mediation, they can have domain expert mediators. Like you said, then in IPR, you need a domain expert. The mediator must be, let us, as I was just mentioning, from telecommunication, then it should have some background from telecom. So, what do you think in today's world, because you do huge amount of IPR disputes, what are the main sectors, areas where as a mediation service provider, I should look at that, okay, this team, at least minimum 10 sector of mediators I should have so that we can service large number of companies. So what are those sectors? What are those type of areas where one should have trained or should train the mediator or should have trained mediators in those sectors?
So let me put it like this, that you can't do super specialization.
Yeah.
It's not going to be working very well if you do super specialization. But for example, myself, I am a IP lawyer.
Uh,
I don't have technical background. I have IP knowledge. And over the years, I've gathered that knowledge. It's on the job. And I also understand the technicalities because I've handled inventions and I've filed patents. And I've also filed litigation and mediated IP disputes. So that broad knowledge, in fact, with little bit of specialization, I think is a better mix to handle all kind of IP disputes as compared to doing, you take somebody who's highly mechanical, civil engineer or a mechanical engineer, and for them to be as mediators, I think can be a huge challenge because you do need some broad other skills also in addition to the technical knowledge. So I wouldn't recommend having super specialization, but I would recommend having a broad understanding and expertise in IP.
But there may be cases where the things are very, very super specialized. For example, if you are, let us say, in a defense sector or some very high technology sector where the understanding of a particular area is very important to mediate upon. So, do you think any such sectors are there where?
Yeah, so let me give you an example. I had a construction dispute going on. Now there was a construction company and then they the contractors and all that. Now the agreements are extremely technical.
Yeah,
I had a fair understanding because I've represented some construction companies in India for any commercial disputes. But to get into the more specifics of it, because they are very, very detailed and very specific issues that come up, then you take the help of an expertise.
mm,
But I don't still recommend that you have a super specialized mediator.
okay,
Then that person will be doing only that and only that dispute, those area of disputes. Then they cannot do others. Whereas a mediation skill, I think, is much broader. I can do family disputes, I can do IP disputes, I can do commercial disputes, and that knowledge I think helps you more to be more better as a skilled mediator as compared to being super specialized. So
okay,
you have to draw the balance somewhere.
okay.
That's my understanding, but I'm
Yeah.
sure there'll be different views, and I
So,
don't hold
so
my view
maybe
very strongly. But yeah,
that would get balanced the kind of people are approaching an MSP. For example, a space tech company is approaching an MSP, so they would say, okay, I want somebody who knows space tech. So maybe it would also depend upon the kind of parties are approaching an MSP for dispute
yeah,
resolution.
and even as a lawyer, we have matters in court and there's software disputes. We needed a software expert. Then, as a lawyer in this area, I could find a software expert. Otherwise, even doing that is very difficult.
Yeah,
And it's better to have that one said because their qualifications are very different.
yeah.
And their qualifications will help to be an expert on the subject, and their viewpoint will be held differently as compared to a mediator who's skilled in a certain way,
So
who's
maybe
technically skilled in.
a good strategy would be to have skilled mediators and technical people impaneled with us so that he can help the
Yeah.
mediator whenever required.
Yes.
Okay. So
So,
critical moving on.
so
Yes.
resolving disputes through IPR is very interesting topic as I have received numbers of questions for you, ma'am.
Okay.
Yes,
I'll try to answer them all, but
yes.
Samir has already put me on the
No, I'm asking from the point of view if you
kind of.
want to take IGMS towards that direction. So my questions are a little bit to that aspect, and people also want to know all this. Yeah, yes, Kritika, go on.
So as already we are running short of time, so I would take some of the questions today. So the question is, ma'am, like how Indian courts and Indian legal system are increasingly adopting mediation as a method of resolving conflicts related to IPR.
So I have seen disputes both pre-litigation and post-litigation. And mostly now courts are getting, as I see earlier, before I think mediation became the buzzword. I think courts you would give ex parte injunctions far more leniently. Now we see that the court is reluctant to give ex parte injunctions immediately, and they would encourage mediation before they get into that space. So that's the difference we see evolving. Although they still give ex parte injunctions because it's mandatory at some point. Sometimes it's very, very essential for the parties to get ex parte injunction. So that's the difference that we see that is happening, by the courts. We see new kinds of also litigation and new kinds of mediations happening, especially on on the internet and the domain name spaces. We see all kind of new forms of litigation there as well, and IP disputes there. and we have to sometimes interact with ISPs and see how to work with them, and e-commerce platforms. So they all have different kind of uh, IP issues.
So, ma'am,
AI
how
is
does
going to be the big one also.
sorry, yeah.
Yeah.
So, ma'am, how does mediation help in addressing power imbalances between the parties in IPR disputes, like such as the large corporation and individual inventors?
Yeah, so mediation only helps, there are power imbalances, and it's a very, very good question. And it's a very tough one to handle because you cannot change the dynamics of the parties. It's very unfortunate sometimes, and you can see, it's a moral dilemma also sometimes because they're very small infringers, and then there is this huge company who's trying to take out money out of them or whatever, and, to get damages out of them. But frankly, I think the lawyers' roles are very important in this whole process because we hardly get to really see the actual parties, which is the actual IP owner or the actual business people leading the IP ownership. You hardly get to see them. So the lawyer's role is very important here. And that becomes difficult sometimes to settle a dispute. I don't have any, I mean, I'm not holding it as a grudge against any lawyers, but even they can't help it because their parties are not present in India or whatever the issues are. But it also expedites the mediation in a way because the parties as the level playing field can never be there. So they are smaller and bigger parties. So the smaller parties will say, okay, let's quickly finish this dispute. Let's quickly be done with it. It's more cost effective to mediate and get out of it. So that works in their benefit. Mediation works in their benefit. And for the larger player, it is that, they don't want any adverse publicity. They don't want any, uh, difficulty happening later. So they say, fine, let's get out of it. They may sometimes look at a business relationship with the party and it may work out better. I think that's the way it is, I think, in IP disputes.
I think one more thing over here is that the proceedings under mediation generally would not come into public domain. If it is a
Yeah.
litigation, you would have court orders online available. You would have
Yes.
company name appearing. If somebody searches, there's a due diligence. They would have a lot of things coming up.
Yes,
But
absolutely.
mediation, as you rightly said, it would not be, for the companies would not have their name floating here and there in legal documents.
Yes, absolutely right. Of course, the terms of settlement do become court records, but that's only, we try to get limited information if the parties want that in the final settlement. But yeah, you're right. That's a very big
Yes,
plus point for to mediate disputes.
yes, Kritika.
So, ma'am, how can we use mediation as a strategic tool to settle the IPR disputes in a like productive and efficient manner?
I think I have one answer for Samir for his uh, MSP, which is that you can look at co-mediation, co-mediators working in IPR disputes, because then a technical person with a skilled mediator can help resolve your disputes. And that's a very good way to resolve disputes. I think co-mediation really helps in many ways. And then also that, it can be strategically used basically because the outcome is in the hands of the parties. So they can really kind of settle not only what is in front of them, but also which is beyond the scope of the litigation. So a lot of things get settled. You can get a settlement on the registration and the oppositions of the trademark application. So a lot gets settled under that. And a lot also doesn't get settled, which are the criminal, if somebody's filed any criminal complaints, those get, they don't really get settled in that sense. And basically, I think it's all a business decision. So it's how you use mediation, either you use it pre-litigation or post-litigation, is what it is. One of the strategic ways of using mediation is also for negotiating the contract between parties, which I think is an important aspect which you can do in commercial and IP disputes.
And maybe somebody want to delay the proceeding, they would say, okay, I'm going for mediation for some time and then come back after spending some time in mediation and then go back to court.
Yeah, but because now they've made mediation time bound,
Time
how
bound.
much will the party gain
Yeah,
out of it in 6 months? Because I don't think so they gain much now. Yes, if they keep going back and forth, which we see very often it happens. They
yeah.
go back and then we know they're going to come back again into mediation and they come back and then they go back and back. That is something which is, a waste of time for everybody. So
Yes.
that keeps happening. And many disputes never get decided by the court because how do they decide certain disputes? It's very tough to decide certain disputes. So, yeah.
Ma'am, thank you so much for your informative answer. So, moving to our next panelist, this question is for Mr. Sarvesh Kashyap. So, what is the role of institutional mediation? Can institutional mediation handle complex disputes?
So, yeah, hello, am I audible?
Yes,
Yes.
sir.
Yeah, yeah. Yeah, Kritika, that institution mediations play crucial role in mediation. Basically, they provide structure, support, and consistency throughout the process. And institutional guidelines typically covers everything from confidentiality to timelines, allowing parties to focus on substantial issues rather than procedural uncertainties. Institution mediations provides panels of experienced certified mediators with specialized expertise, allowing for a tailored approach to each dispute. As far as your can institution mediation handle complex dispute is concerned, short answer is yes. Institution mediation is well suited for complex disputes due to support, expertise, and infrastructure that the institution provides, like IGMS deals with cases involving multi-jurisdictional or high-stake conflicts through experienced leaders. And institutions can manage everything from commercial disputes involving multiple stakeholders to international conflict that requires expertise in cross-cultural communication and international law. So yes, that institutional mediation can manage complex dispute.
So, Kritika, I would like to add here कि when you say complex dispute, whether institution can do complex dispute means you would definitely require very skilled mediators, and
Mm.
the parties should also rely upon those mediators that yes, they are skilled to deal with complex issues. So
Yes, yes,
now institutional, what MSP would do, because as a party I would not know who is such mediator. I think the starting of dealing complex mediation is getting the person who can deal with complex matters. So I think only
yes.
MSPs can go around, find the people, and panel them, and get them on a plate to the parties who want them. So that is the
Just like that, Girja Madam explained that for handling the crucial matters, that super specialized mediators are required.
so
So
so maybe
specialization is mandatory.
maybe MSP may be helpful in getting skilled, no, maybe not technical, but the skilled mediators who can deal the complex. So the finding those people would be difficult for the party individually, but the MSPs with their network, with their professional contacts, they can get those people on board and put it in front of the people. That I think that is the start of very first start of a doing complex matters. I think instead of individual mediator, and MSP would be far better situation to deal with complex mediations by bringing in different expertise on the plate.
Right.
So, we come to the conclusion of our webinar. I would like to thank Ms. Girija Krishnan Verma, Mr. Samir Rastogi, and Mr. Sarvesh Kashyap, I would like to extend my thanks on behalf of India Jurist Mediation Services to Mr. Sarvesh Kashyap, Ms. Girija, and Mr. Samir Rastogi for enlightening the participants. And I would like to thank the participants who spared their time and listened to the speakers. And I hope they have resolved their queries as well as they have gained clarity and practical aspects of mediation in IPR. Thank you so much for your
Thank
time
you.
and presence. Thank you all.
Thank you very much.
Thank
Thank
you,
you,
Kritika.
Sujaji. I think those people who want to see it or want to refer it to someone, this is available on recordings that will be shared with everybody.
Thank you.
Thank you very much. Thank you, madam. Thank you,
Thank
Sarvesh.
you all.
Thank you very much.